statute in Goal 5 requires any more than addressing a plan. We're already hearing zoning and code and other restrictions, and I don't see a definition of fee title property rights involved in any of this. And that's the fact that people own fee simple title. They do not own restrictions, and I didn't think even DEQ had the statute right to put these zones on top of property without compensating the individual. And if you can show me the actual statute in Goal 5, which was already pushed down in Medford, because there is no actual operating statute for either zones or codes. It's only for a plan. And I'm very interested in what you would say about the actual statute requirement for this to be brought to the landowner when they actually own the property.
Well, so Goal 5 has administrative rules that are applied to it.
That's right. The Goal 5 administrative rules do not require zoning and codes. They require a plan.
Well, there are. Let me answer your question real quickly. Goal 5 administrative rule requires counties to adopt a program to protect riparian resources. And
okay, so are the statutes in there? That in the requirement that these people are going to have to go through the zoning, because you are blindsiding these people with 4 separate options, none of which make any sense to a person who's come to their first meeting.
Right. Well, like I said, this is the 16th meeting, and we're not done. We're going to keep having them.
I really think that these people need more information.
Well, we'll do our best to get as much information out as we can. Okay. So sorry, sir.
As a landowner in LC, I mentioned earlier, or you mentioned earlier, not I did, you mentioned earlier that you were under directives by the state, correct? And setting this up?
Okay. Right, part of it is
okay, are you aware that the 14th Amendment, as stated and as adopted in 1868, clearly states, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. In other words, you're telling us what we have to do with land when it's against the law for what you're trying to do. Because you're telling us we have to when we don't want to.
Well, whether this program violates the 14th Amendment of the Constitution is honestly going to have to be something for lawyers to sort out.
No, it's not for lawyers, because you're the ones telling them that they need to adopt this. So consequently, you are saying, break the law. You're telling them, break the law, make these people do it. You're telling them this.
Well,
and this guy here is doubly bad because he's DEQ. And he thinks because he's operating with feds is above the law too, and that's not true.
Well, we'll take that seriously, and it's not the first time I've heard that brought up, and I know that's a concern.
Well, study fee simple title rights. Fee simple title
Can we'll I like the people that are raising their hands, and we try to get as many comments as possible.
Sorry, let me clarify. So, for a few more minutes, we want to take questions that people have to understand what's being proposed. And then we're going to open it up to discussion about how the proposed code could be improved. So, and again, as I said at the beginning, we've heard that some people want it to not even happen. So we understand that.
Why don't you ask the question if anybody has any questions first?
Well, we did. So does anybody have questions to help them understand what's being proposed to code? And Patricia had her hand.
So under G on page 9, the word buffer is used, and it was not used anywhere else, and I was wondering why the word buffer is used in this option, as opposed to riparian area or something like that.
So in which option?
So option D on page 9, the word buffer is used, buffer width. And okay. I have an idea, but I don't know if I'm right, why the word buffer is chosen for this option as opposed to continuing with the word riparian or some similar.
Okay, so did folks hear that? You want me to repeat it?
Repeat it, please. Okay,
so in option D on page 9 of the draft, the title of that is variable buffer widths. So the word buffer is used in that. It's not used elsewhere in the code, and so she's wondering why that is. That's an unintentional switching of words. Yeah. So buffer widths is a common way of describing these areas, but that's, we want to be consistent with our wording, so we've noted that. Okay, I'm sorry, Adam, you?
No.
Okay.
Trying to figure out who's going.
Well, on the
Oh.
list of options, I saw 4, and I presume there are other possible options, but I did not see an option to do nothing.
Right, we definitely noted that option.
Pardon me?
We haven't put it in the,
So we definitely have heard loud and clear that people, some people, most people here tonight, it seems like, have noted that they want another option to do nothing.
Good,
Well,
good.
when we came up with this draft code, that wasn't an option because that wasn't the intent.
But let me reiterate one more time. When this goes to the county commissioners, one of their options will be to not adopt the code.
Oh, okay.
That's an option.
One of the
multiple
options,
minds.
one of the options is to not adopt the code, and that is up to the Board of Commissioners. But what I would suggest is that you take a good look at the code between now and the Planning Commission hearing, and the Board of Commissioners hearing. Because if the code is adopted in some shape or form, it sure would benefit from your suggestions on how to make it more flexible for property owners who do want to, for an example, put a barn, 25 feet away from a stream in an area where normally it's a 50-foot setback, and to look at those different options and see if there's a way that makes sense for you to be able to do what you want in order to maybe protect some other area next to the stream farther away where, you're fine with not doing anything anyway. And so I would suggest that you do look at the options in between now and the Planning Commission hearing and the Board of Commissioners hearing, just see if there's any input you have that could make the code better if it is adopted.
So, sorry, Gary.
When you're talking about the 50 and 75-foot buffers, is that from the middle of a stream, the low water mark, the high water mark? Where's it from?
The riparian widths or buffers that we're talking about would be measured from the top of the bank of the stream.
Obviously, you're afraid of me.
No,
Let me
sir.
give you my credentials.
Just a second, sir.
No, I'm
No,
gonna get to this.
Okay, all right, I will let you in 1 second,
Yeah,
1 second.
How
I
do
just-
you do it?
So, from your vantage point, maybe you can't see, but there are a lot of people raising their hands, and I'm not avoiding you, and I will call on you now, please. I'm interested to hear what you have to say. Thank you.
All right, I am Shaler Scout. I took my EIT in the city of Corvallis. I was the Director of Public Works for municipalities in the state of Oregon. I specialized in water and sewer. I either gave it or received it. And one of the things about riparian, and to answer this gentleman's question,